Let's talk about privacy law and about contract terms around compliance with privacy law. This is incidentally not a course on privacy compliance more broadly. The obligations of privacy law require a lot of activities outside of your contract. They require you do a lot of things with personally identifiable information you may have, and that's entirely separate from this course. Stuff that is, though, worth learning. Privacy law also has a set of requirements, at least many privacy laws, for what your contract does say. Required terms of your contract. We're only going to touch on some basics about that. That is also a very large and separate topic, but I want to give you a basic understanding of what we're dealing with when we talk about privacy law and when we talk about compliance terms. So first of all, the landscape of privacy law is complex. There is no other way to put it. It is very problematic. So first of all, in the United States, there is no general comprehensive privacy law. The US does not have a GDPR, a general data protection regulation, like the European Union. The EU does have a general broad privacy law. What the US has is some sector-specific privacy laws. So you've got, for instance, HIPAA, the Health Information Portability and Accountability Act. That's a privacy law specifically about health-related data of a certain kind. It has specific requirements for contract terms. If you've got HIPAA protected data, protected health information, and you share it with your vendor, it's got to be under a business associate agreement. That's an attachment to your contract. Or Gramm-Leach-Bliley or several other federal statutes are about, the Gramm-Leach-Bliley Act, GLBA, are about private data that is finance related, credit data, etc. We do, however, have in the United States some broad general applies to everybody laws about privacy like GDPR that are coming out of the states. California led the way with the CCPA, the California Consumer Privacy Act. And many other states have jumped on the bandwagon since. Virginia, Colorado, Connecticut, etc. A bunch of US states have privacy laws. This creates a problem. This set of generally applicable to all consumer data privacy laws creates a problem because I can almost guarantee you that whatever your business is nowadays, you're not just operating in one state. Certainly, if you're dealing with data terms in your contract, you are most likely dealing with terms relevant to cloud services, relevant to services that are provided online. That's where data terms are most relevant. And that's not you don't see a lot of businesses that are operating online that are really limited to one jurisdiction, not even one country. So what do you get? You get sometimes conflicting, overlapping laws governing the data, governing the privacy of this data subject or that data subject, different people. That makes it very hard to comply. You could have multiple different laws applying to the same set of data that you're holding as a unified whole. And it gets worse than that, of course, because the European Union has its very famous, very substantial privacy law, the General Data Privacy Regulation, GDPR. GDPR is applicable to people outside the European Union, at least that's the EU's position, if they receive data about EU consumers, if they receive private data about EU subjects. So very likely, almost any deal you're doing involves data that is governed by GDPR, as well as various US state statutes. And then there are other jurisdictions around the world that have their own privacy laws. The UK has its own post-Brexit version of GDPR. Brazil, New Zealand, Quebec, lots of jurisdictions have their own privacy laws. This really creates a mess. It really creates a very complicated setting. And this is not how the law is supposed to work. And I just want to make sure you have no doubt about that. The law is not supposed to be a full employment guarantee for attorneys. The law is not supposed to be difficult to comply with. We're supposed to be able to tell what the law is, and if we have goodwill, we want to comply with it. Unfortunately, due to the variety of jurisdictions enacting privacy laws, and due to the fact that most of us are operating in multiple jurisdictions, and due to the fact that we might not even know whose data we've got in our contract, whose data is relevant to our deal, It can be very difficult to tell what you're supposed to do to comply. And that's, you see the concerns there on the screen. In some deals, it's not even practical economically to figure out what laws apply. It shouldn't be like that, but it is. And in some deals, it's just not even possible. You don't know where all the data is coming from. So what do you do? So if you're on the customer side, you may have run into vendors who will not promise to comply with privacy law. You want a pretty standard clause in your contract that says vendors shall comply with all applicable laws, all applicable laws related to the service, or all applicable laws related to the data. And to your astonishment, the vendor says, no, we will not make that promise. So for a lot of customers, the natural and immediate reaction is to say, I had no idea we were dealing with gangsters. I had no idea that we were dealing with criminals. I thought we had, decent people on the other end of this deal. And I want to encourage you not to think of it that way. The fact that your contracting party will not promise to comply with the law does not mean that they plan to violate the law. It does not mean that they're criminals. It does not mean that they consider themselves outside of the law. Think about what a promise to comply with the law means. The law is the law. It's binding. It does not need anyone to promise to comply with it. It's just the law. So by your contracting partner saying we're not going to promise to comply with the law, they're not saying we see ourselves as outside of the law. What are they doing? If they violate privacy law by accident, which is how it's likely to happen, they're facing some serious consequences. They have consequences of possible enforcement actions by various government agencies, wherever the data comes from. And they have the potential of lawsuits by injured consumers, people whose privacy has been infringed. If they promise to comply with privacy law, they add another consequence, which is breach of contract. That's what it does. It adds to the existing set of consequences for potentially accidentally violating privacy law that you've now got breach of contract liability. So yeah, some vendors are not willing to make a broad promise to comply with privacy law. And if you're on the vendor side, I would seriously consider not making that promise and trying to explain to your customer what I've said. No, it doesn't mean we're criminals. It's hard to comply with privacy law. Sometimes the vendor has language that says that it is not promising to comply with any law that's not applicable to it in the jurisdictions that it does business in, listed in attachment B, whatever that might be. There's ways to describe this that can help you restrict, it can make a compliance promise, but help you restrict what it is. But you should consider the consequences of promising to comply with privacy laws when you don't necessarily even know what they all are. And if you're on the customer side, you just should be aware that that doesn't mean you've got a criminal on your hand. There are some privacy laws that may be applicable to your data that actually require specific promises. The CCPA, for instance, the California statute requires that the recipient of the data, the processor, although that's not the term used in CCPA, certify that it understands various requirements of the law. And you may have other laws that require specific promises of compliance. Yes, you got to put them in that case. And if the vendor says no, you really do have a problem. If you're the customer, you say, this is actually required by law. You've got to make this promise. So that's the exception. You definitely do want to put in those clauses, but be aware, not all the privacy laws have specific requirements. They're still binding, even if you don't promise to comply with them. Another quick note about privacy laws, or really a related point. Why would you promise to comply with your privacy policy? It's kind of like this issue about whether you're going to comply with privacy law. Your privacy policy is not a contract document. A lot of vendors have in their contract that they will comply with their own privacy policy, or the customer puts it into the contract. Once again, you have consequences if you don't comply with your privacy policy. It's a statement to the public. You violate it, you could have liability to third parties, you could have enforcement actions by government agencies. Promising to comply just adds breach of contract to that list. So understand that a privacy policy is a statement to the public about what you do with confidential information. It is not a promise to your contracting party. It is, in a way, more powerful. It's a broad statement. So I'd say delete that clause that says you promise to comply with your privacy policy. That's the compliance issue surrounding privacy law. It's our sort of thumbnail review of what to do about this very hard topic. If you found this video useful, please come check out Tech Contracts Academy. We provide training on drafting and negotiating contracts about artificial intelligence, cloud computing, and other forms of software. It's all for lawyers, contract managers, and any business people involved with contracts. So please come check out our programs live and on demand at techcontracts.com.